Thank you for coming today. My name is Jonathan White. You met Anna Ray in the background, and I'm excited you decided to spend some time with us tonight. We'll talk about one of my favorite topics, which is estate planning. I get really excited about this.
Oh yeah.
I do. I love it. I think it's awesome. I can't wait to share it with you. But before we get going, I want to do some housekeeping with you. Anytime you want, there's some snacks in the back. Feel free to get up and help yourselves. The restrooms are in the back. And you're going to see a curious young man walking around with a camera. He happens to be my youngest son. And he happens to have a student side hustle business called gwhite.jpg, where he goes to sporting events at high schools and takes pictures. And I thought, what a great way to get some pictures for us, but to make him come here tonight, spend time and move around the room. So you'll see him moving around. That's what he's doing. And thank you for bearing with him as he tries to make us look good. How to participate tonight. This is totally interactive. So please, raise your hand if you have a question. I may ask you to let me finish my thought before I answer it, but I don't mind addressing things as they come up. Of course, at the end of the presentation, I will have time for questions, but if something's really gnawing at you, put your hand up and I'll talk to it. In the meantime, we have pens up the front. You got your booklets. There are lines in it if you want to take notes, if you didn't bring paper. But please take plenty of notes, use the materials we have, and be ready to be interactive. We have some goals, right? Let's talk about what we want to achieve tonight. If we don't, we're just talking into this. So my goals for you tonight are to really simplify what the estate planning process is. Because for a lot of people, it is scary. There are a lot of legal words in it. Some of you may have gone through the process with family members and still don't understand what it is. So I like to try and simplify it, easy to understand terms, so we can get through that base level. I want to give you practical insight. I want you to have knowledge that you can put to work for you right away. I don't want this to be an esoteric academic exercise. I want it to be boots on the ground. You understand what you would need to do, which then leads to my last part, to really empower you. So when you get done hearing all of this, you're excited, you're energized, and you're ready to go and take care of whatever your or your family's needs are. That's really the point of this, right? It's not just to gain information and walk away and go to the barbecue this weekend and tell everyone this awesome information you have. It's to make sure that you're taking care of yourself and your family. So if we can hit those three goals tonight, this will be an awesomely successful presentation for us. This is usually the point in time at a presentation where most people will stand up and tell you how qualified they are to be talking to you. And they will roll out accolades of academic degrees and how they achieved the highest level of those degrees, and then went on to do all kinds of awesome things, teaching other attorneys how to do things and entering academia. So I put together this word salad of all those things. Yes, of course I went to law school. Of course I had to go to college to go to law school. Of course I went to high school. I did well enough to graduate. I did well enough to pass the bar exam, and I've kept my practice alive since 2009 when I hung my shingle after my first 10 years of practicing. But none of those accolades is why I think you're here listening to me tonight. I think it's because of the practical knowledge that I've kind of gained over the years. Before I hit the slide behind me, I do want to tell you about that first. The first 10 years of my career, I was not an estate planning attorney. I was a trial attorney. I went to court and I defended people. Then, when I hung my own shingle, I was sick of working for other people. I intended to do that, but instead of defending, I was going to switch to the other side and be a plaintiff's attorney, be a criminal defense attorney. And as I was doing that, I found an attorney that said, hey, you can help me out. And I ran real estate closings for him. Slowly picked up a transactional practice, and then realized during the course of that transactional practice that the experience I had gained in the courtroom really helped out. because I saw what happened when things didn't go right in the plans and the documents. And that was insight that was different than other people. Despite that, when we talk about the surveys, we transition to this, I know all of these to be true. I knew it when I started practicing as a trial attorney. I know it now as an estate planning attorney. And we're all getting towards why I think I'm here, qualified talking to you. So, the survey says, this is from care.org, which I think is the leading kind of information gathering in the estate planning world. So, care.org will tell you if you have to go through the probate court process, that's the process of bringing documents through a court, it's going to eat up 10% of the value of the overall estate. It's a lot of money right there. It also will tell you in the information they gave you that 35% of all Americans dread the probate process because they experience some type of family conflict having gone through it themselves with a parent or a different loved one. Despite those numbers, 67% of Americans either don't have a plan, and when you look at the 32% of Americans that have a plan, I didn't put this on the slide because I ran out of room, 82% of that 33, crazy math, haven't updated their plan in over 10 years. That's akin to not having a plan, and you'll see why down the road. I know all of these numbers. I know them to be true. I see them in my practice. Despite all of that, the reason why I'm really qualified to stand up talking to you is I have my own family. I told you my youngest son is standing right there. So, who knows the parable of the cobbler and the cobbler's kids? You hear this one before? Everybody in the town has shoes except for the cobbler's kids, because he's so busy helping everybody else, he didn't help his own family. This is a really funny proverb. It's actually true. One of the earliest cases I had when I had transitioned out of working for law firms, the Register of Probate in Middlesex County, so that's the person that is in charge of recording deeds and making sure real estate flows smoothly in Middlesex County, which is the biggest county in Massachusetts, as far as population goes, passed away, and he had no estate plan. So you would think the Register of Deeds would have an estate plan. He didn't. I bring this up as a way of kind of humbling myself to you. I'm the cobbler. Where I was, Gabby, till what, 3 weeks ago? When did we have the family meeting? 3 weeks ago?
Something like that.
Yeah, see, I'm always paying attention. When my wife Karen had our first child, Thomas, who's now 21, we did a will. We did a power of attorney, we did a healthcare proxy. And I did exactly what I tell my clients not to do. We put it in our sock drawer and forgot all about it. And just let it sit there. And although we said to ourselves time and time again, we need to update this, we never took the time. In large part because Carrie just said, I would just do it, right? I do it all day for people. I'm just gonna do it. We never did it. And then finally, we set it as a goal to change it. And Anne Marie stayed on me, we got it done. And despite knowing all of these percentages, despite seeing the good, the bad, and the ugly, I just let it sit. And when I was preparing this, because this is a change, I've added this kind of story to this, because now that it's done, I can brag about it. I thought about why. And the low-hanging fruit is, yeah, I was busy doing it for everybody else. But that wasn't the real reason. The real reason why is my family is broken. I wasn't sure what decisions I wanted to make if my immediate family, my wife and children were gone. Because, for example, I have a brother who I would never, ever, ever want to get anything from me because he wouldn't know what to do with it, and his already shambled life would get worse. And like many Americans who know all of these stats, I let myself get paralyzed. Because I was dishing this information out to people on theirs. When they tell me, oh, I have a brother and I don't know what to do with him, I could say, you want to do this, that, and the other thing, right? I wasn't giving my own advice. So I think the reason why I'm qualified to be here, not all the degrees I hold, not all the years I practice law, I go through this just like everybody else. I struggled with decisions. I waited, I delayed, but I also had a good experience. And this is the story of Tony and Janice. So Tony and Janice are my maternal grandparents. There's not a milestone life picture of mine growing up that they're not in. They were second parents to me. Unfortunately, my mother was their only child and she passed away in 2014. That put me in the role. Because I certainly didn't put my brother in the role, so it was me. And what happened was, as they got sick and then eventually passed away, I saw the care and the thought and the love they put into a well-considered, well-drafted, and well-funded estate plan. And when we had to step in and act for them, it was easy. When we had to transition assets through their estate, it was easy. And that's the goal I have for everybody now. I want it to be as easy as Tony and Janice made it for me. And by the way, they were always Tony and Janice, even when I was like 4. We never called them Grandma and Grandpa. I have no idea why. They're always Tony and Janice. So that's why I love estate planning so much. That's why I love talking about it, and that's why I've kind of set this path for my career of wanting to help people do this. Because I've been in the trenches when we don't want to make decisions, we let it hold us back with my own family. And I've also seen the benefit of a well-executed, well-funded estate plan. And to me, there's no greater expression of love as you're transitioning from this life to wherever you go to than making it easy for your family. That's why I love talking about this, and that's why I would argue with you I'm qualified to do this. All right, ready to buckle up and get into this? All right. We're going to talk about 2 things tonight. We're going to talk about wills, and we're going to talk about trusts. Underlying both of those are these other documents that, regardless of what type of a plan a person has, being a will-based plan or a trust-based plan, we have. I'm going to go over those quickly first. That way you just understand these are part of everything. And those documents are what we call the incapacity documents. Some people call them ancillary documents, but they're documents we would use if you're alive, but not able to make your own decisions. You have to empower somebody else to act for you. If you don't have these forms, someone has to go to court, which costs time, costs money, and you may not get who you want. And those documents are a power of attorney. And that's just a form that says, I would like this person to make financial, legal, business, anything that's not health, right? That person would handle anything that's not health if you're incapacitated. The other forms are a healthcare proxy. That's a form where you empower someone to make medical decisions for you. And the last form in this kind of series of things that underlie every type of a estate plan is what we call a HIPAA authorization form. And this form simply says if your healthcare proxy needs to access medical records to help them make a better, more informed decision, they can have access to them. As I said, these are documents we use if you're alive, but incapacitated. If you regain capacity, the documents sit there and you make your decisions again.
What's the last document called?
I'm sorry,
HIPAA? What's it called?
HIPAA authorization. Yeah, HIPAA. Once you pass away, those documents have no more effect. That's when we then transition to wills and trusts. So I'm not really getting into those documents in great detail tonight, but I wanted you to understand that they're part of a well-founded estate plan, and that's what they do, okay? But, yes.
Where do you get those documents?
Well, if you come to an estate planning attorney, they will include them as part of your plan.
You can't do it yourself.
Can I hold that question to the very end? I won't forget because it's actually on a slide of mine. Can I do this myself? Can we do that? All right. But yes, when you go to an estate planning attorney, they will include those documents. One thing that happens a lot is I will be in a conference with a potential client And they'll say, oh, I don't need a healthcare proxy. The last time I was at the doctor's office, they put one in front of me and I signed it. I said, okay, that's great. I'm actually really glad they did that, because if you don't have one, at least for that visit, you have something in place. But what a lot of people don't realize is those documents are not portable, meaning you can't use it anywhere outside of that facility. I would argue for that visit, but I can concede it if not. And it's not robust. It doesn't have what a well-written healthcare process is. Better than nothing. So one of the challenges I often face is telling clients, now that you have this awesome set of documents, don't ever sign one of those again. Because if you do, you inadvertently delete the one that we did for you. But I will definitely answer the, can I just do this myself question, okay? If you can have some patience. All right. So wills. What is a will? A will is simply a document someone signs that is a set of written instructions. When you have a will, it means your family's going through the probate court. A will does not avoid probate. The difference between going through the probate process when you don't have a will, as opposed to when you have a will, is with the will, you've made the decisions. You've said who you want to be in charge, and you said where I want my stuff to go and how is it getting there. Whereas if you pass away without a will, the legislature in the Commonwealth of Massachusetts makes those decisions for you because it passed a set of laws. And the court simply follows those laws. But you go through the same process nonetheless. But it's an important document. I don't want to minimize it. It does a lot of things for people. As I mentioned, it is a set of instructions. And the ability for someone to really control what happens after they're gone is powerful. Because you don't want to fall to the legislature's plan. You don't want to fall to the Commonwealth's plan. Because it may not go the way you want it to go. The court may not even put your family in charge. I happen to sit on a list of attorneys. Sometimes judges will say, we're appointing the next attorney on the list. Who is it? Attorney White, you go. And I'm in charge of someone's estate. A will also let you make very specific instructions. I like to joke about the action figures, but we all have prized possessions that we want to see somebody get. So you can get as detailed as you want, right? So on the one hand, you can say, I'm just leaving everything to my 3 boys, or you can really spell out specifically how things are getting there and who is getting them there for you. That makes sense. But at the end of the day, all it does is says, this is how I want my stuff to be handled when I'm not here. Okay? Benefits. Generally speaking, a will is straightforward to set up. It's not overly complicated. There's a few decisions to make. Who's in charge? That person's not around, then who's in charge? Who do you want you to leave your stuff to? How do you want to get it there? Not bad. You're going to hear me talk about cost effectiveness throughout this. There is no doubt, from a document creation standpoint, from paying a lawyer to make your documents, a will is the most cost effective, meaning it's the least expensive. After we talk about the cost and trust, I'm going to dispel that, I hope, for you and say why it may not be in the long run. But from money out of your pocket today, if you're signing for a plan, will plan is the least expensive. You will put the least money out of your pocket today for a will plan. If you have minor children, a will is where you select guardians. So even if you put a trust in place, you still will use a will to appoint guardians of minor children. You cannot do that in a trust, so it serves a very important function there. One other thing while I'm here, of course, and I think this goes without saying, but I want to say it. If you have a will, you retain control of everything, and you can change your mind at any time. You simply amend the will, restate the will, update the will, shred it and do a new one, but you retain control of everything. Okay? Drawbacks. Well, we started talking about this probate process. I'm going to get into it in a second, but going through the probate process is a drawback for most people. Why? There's 3 reasons why. The first one is it costs money. The second reason is it takes time. And the third reason is it's a public process. So, money, time, publicity. Yes?
The state has to be of a certain value before we have to go to probate.
No. There are 3 different types of probate processes out there, one of which is triggered by a dollar amount. So essentially, if the value of your estate is less than $25,000, so if you own a home, you're already out of that, you can use a process we call a voluntary administration. Think small claims for probates. But essentially, if you have an asset in your name and you pass away, that asset is going through the probate court. If you have a will, great. If not, legislature told you how to do it, but it's got to go through the court. The reason why they put the $25,000 limit in is you literally walk in, process the paperwork the same day, and walk out because they realize it's a lower value estate. But there's probate is about titling assets. So you have to go through a court process to retitle that asset. That answer your question? All right. So let's talk about this, because I really want people to understand the probate process, because it goes to the heart of why we pick and choose different documents. So time. Now let's do cost first. To put a will together does not cost you a ton of money out of your own pocket. So a lot of people say, will's the cheapest way to go. As I mentioned to you, yes, from a document production standpoint, people pay me more to put a trust plan in place than a will plan. But when you pass away, the cost to take a will through the probate court adds fees. Remember that survey says slide? I told you a probate court process will eat up about 10% of the value of your estate. So you may have only shelled out a small amount of money to prepare a will, but in the long run, your family will lose about 10% of the overall value of your estate in costs and fees, taking that will through the probate court process. So if, trying to get 100 cents on the dollar to your loved ones is important, we've hit a roadblock here. Yes?
So the 10% is regardless of whether you have a will or not. I was assuming it was if you didn't have a will, it's 10%.
I will tell you that number will definitely increase if you don't have a will.
I see.
Because you'll sit, someone like me will sit in court longer, have more hearings. They will likely appoint an attorney to look over someone's shoulder. We call it a guardian ad litem, and all those things add more costs.
So you're saying that 10% is the minimum, in general,
It's like the average. It's like a national average.
Average,
yeah.
Even if you have a will.
Right, yeah, going through that probate process. So that's kind of how the costs work, right? That's the hidden cost of a will. Later on, someone's going to pay to take it through. Time. And there's 2 measures of time we talk about. The first is how long it takes to get the piece of paper from the court that says, yes, I'm in charge. The second is, when can we actually disperse things to our heirs? So, when we start the probate process, the whole game we're playing is to get a piece of paper that we call letters of authority. And it's literally a 1-page piece of paper signed by a judge that says, Jonathan White is the personal representative of the estate of Kerry White. My wife, I'm like, mad to happen. I'm sure you made fake names. It can take 60 to 90 days to get that piece of paper. If, you're firing on all cylinders, there's, the family's getting along, we have everything we need, it's 60 to 90 days to get that piece of paper. Now, how do I know that? I do this service for clients. In addition to writing the plans, I administer them when they pass away. So I'm in the courts. We go through this process. Anne Marie can tell you how sometimes we get out super fast, and sometimes we just sit there and languish, and there's nothing we can do. We will call, we will email, I will show up, and it's just, you're in line. Welcome to the probate court. That's important, because what I want to convey to you is, when you pass away, and your will is the document that's controlling, until the court issues the paper that says the person you said's in charge is in charge, nobody's in charge, because no one has authority to touch those assets of yours. So imagine, if you will, you own a house. And your will says, my house is going to my 3 children in equal parts. You hire an attorney, your children hire an attorney to probate your estate, and during those 60 to 90 days, no one has access to your bank accounts. No one has access to the house. I mean, don't get me wrong, people will get in if their kids have keys, but no one can control it, so they can't sell it, you can't do anything with it. And if you can't access mom and dad's bank account to pay the bills, you better hope those 3 kids have enough margin in their own budgets to pay those bills. I'm not saying you're gonna get foreclosed on in this time, because banks aren't gonna foreclose if you miss 1 or 2 mortgage payments. But interest, fees, things like that could happen. So that all puts stress on the situation. So first measure of time, 60 to 90 days to get the piece of paper that says I'm in charge. Once I'm in charge, I can now go command bank accounts, everything I need to do we call it marshaling the assets, and start paying the estate debt. Because my whole job now as the personal representative is to get a net amount that I'm moving on to the beneficiaries. So if 60 to 90 days is how long it takes to get that person put in charge, ready for this one? No one's been through this process. In Massachusetts, no one's been through the probate process? Okay. Does that ring out to you? Does that sound about right? Do you remember?
Mine was not as difficult as what you're saying, but yeah,
it takes time. So here's the second one. You have to wait a year from the date someone passed away until you can distribute any net proceeds. And here's why. When you pass away, anyone that you owed money to, any creditors in your life, are now creditors to your estate. There's a legal process creditors have to go through, and in Massachusetts, that process is allowed 365 days from the day you pass away. So if we get through that probate court 60 to 90 days, and we pay all the bills, and we know what the net amount is, and the personal representative gives the money out, and on day 364, someone surfaces and says, I'm owed a debt, and you've given the money away, you've breached your fiduciary duty. Who knows if those folks still have the money when you say, I need to claw some back to pay this debt. So in a perfectly compliant legal world, an estate administration attorney will not disperse money for a year. They'll play it extra cautious. In reality, what happens is the attorney works with the representative to watch bills, monitor those kinds of cycles, make some guesses, and give a little money out here, a little money out there, always holding something back, making people sign forms when you give them money out that says, I understand I'm gonna have to give this back. So it's just like a joke, like, why even give it out? So that's the second measure of time. So that defeats the idea of getting things to your loved ones fast. And this third one's the one that kills me. And it actually happened today. And I'm gonna do something I don't normally do. And I think she's gonna get really embarrassed, and she's already shaking her head no. All right, we'll play it a different way, Anne-Marie. So, going through the probate court, I was gonna try and get her up here to tell the story, but that's a bridge too far right now. Going through the probate court's a public process. What does that mean? It means any of us could get on a bus right now, well, it's closed, but today's during business hours, go to the Salem probate court and ask to see the file of someone we know who's deceased and is going through the process, and they will give us the file. We can go to any empty table in that probate court, sit down with that file, and pour through it. One better, we don't even have to go to the court. It's all available online now. You can sit in the comfort of your home and search the probate docket. And as you go into the docket, you can access PDFs of all the forms we filed at court. The only one they tend to not share publicly is the death certificate because it has a social security number on it. But you can see everything else. I mentioned earlier, I think it's really important that you understand the probate process because you understand how you may want to make choices on these documents. When you go through the probate process, the person in charge, they're working with the lawyer, will fill out all these different forms and file those forms with the court. Inside those forms, there's all kinds of juicy information, like what are the assets of the estate? So you'll list the house, you'll list bank accounts, right? Maybe not like the particular account numbers, but they'll see a bank account, they'll see a value, they'll see a house, they'll see real estate, they'll see real property, they'll see a number. When you get further along, then you got to put all the juicy stuff in. But even at the beginning, you got to put the assets. Then you have to put the name, address, phone number, email of who's in charge, of who is entitled to inherit, and of who the will says will inherit. Who can guess what has happened? What industry may have cropped up when they figured out you could get this information? Any guesses? Driving in here today, do you see any signs that say "We Buy Ugly Houses"? Or have you seen those driving around? Anne Marie and I got an email today from a realtor that said, "Hey, we see you represent the estate of so-and-so. Would you be interested in selling their house? If so, please hire me to be the realtor." That person got that information doing the process I just described to you. They went to the registry of probate and just sat there for a day and called information. And they probably sent, 50 emails. They get one hit, it was worth their time.
I got a half a dozen of those kind of calls from different people.
It happens. So that's the third thing that really to me says, I don't know about a will if I have to go through that probate process, okay? But it's true, it's out there, they happen. The realtors are lesser, like they're softer with it. The We Buy Houses people, it's relentless. It's robocalls, snail mail, email, and that's just the real estate people. There are all kinds of other people. Ever watch those shows like TLC, like I Just Won the Lottery? And it's like, because that's a public thing, people come out of the woodwork with all these investment ideas. Same thing happens. People will target estates worth a certain value and come at these people with all kinds of bogus investments because they know there's money there. They know they're grieving and may not have their full capacity because they're grieving, make a dumb decision in the moment. So, a will means probate? Yes.
I was wondering, during this probate process,
Yep.
you're deceased, and if you have a co-signature account that someone else can take money out of your account, can they do that?
So you asking me if I had a joint account with someone while I was alive?
No,
Okay.
not a joint account. You have a backup family member that can take money out of their
Like a co-signer on the account?
Yeah, co-signer.
Yes, no. A co-signer is very similar to power of attorney. Once someone passes away, the co-signer's authority extinguishes. But, since we're talking about this, I'll anticipate a question. Because I get this all the time too. Well, I'll just put someone on my account and make them a joint account owner. And that way, when I pass away, there is no probate because that account will just move to the joint account holder. Which is a true statement. Anything you own jointly with somebody avoids the probate process for the first one to pass away.
It's automatic, right?
Exactly, by law. You might have to show up with the death certificate, but yeah. Yep. Sounds pretty good. Let's go move all our bank accounts and put our kids on them or whoever we know, love, like, and trust and be done with this. The downsides to that are huge. First, they're a joint account holder. They have equal right to that account as you do. So one, if they want to be nefarious all of a sudden and empty that account on you, there's nothing you can do about it. probably less likely to happen than something like this. That person you put on your account will say your child has a car accident. That account is their personal property as much as yours. And while there's a lawsuit ongoing about that, you can't deal in that account because you have to preserve it in case there's a judgment to be paid. Well, we have insurance for that, right? We do. But courts don't care about insurance. More importantly, what if that person gets divorced? That account is on their pink slip. That account is on their accounting slip and is part of the divorce. So we have other ways to accomplish the same ease of transfer without all those the plane's gonna crash kind of scenarios. If it's not a bank account, if it's real estate, some people will say, oh, I'm gonna deed it to my children and keep a life estate. And when I pass away, it's just theirs. True statement. But if you ever wanna do something with that house, they need to agree. When you pass away, you lose something called a stepped up basis. That's a tax thing that basically says, if you bought it for $1 and sold it for 10, you pay taxes on that $9 difference. Well, if you pass away and your children inherit it from you, and it's worth $5 when they inherit it from you, then they only pay capital gains taxes on 5 to 9. When you life estate something, you lose and give up that stepped up basis. So again, convenient, has issues, can work. Some situations it makes sense to do it. But you lose that big thing. So when the kids go to sell the house, now they're paying capital gains taxes on $1. So that's all the bad stuff about a will. I mentioned earlier there were benefits. I don't want to forget it. I'm not saying wills are all bad, but those are the drawbacks, and they're considerable. So how do we temper this? How do we kind of figure out ways to ease the stickiness of a will? And that's with a trust. And I have to pause here because there are all kinds of trusts in the world. They're not all equal. We are only going to talk about one kind of trust today. If questions come on other kinds, I will answer them, but from the estate planning presentation, when we're choosing between a will or a trust, we're only talking about what we call a revocable living trust. A revocable living trust. That's the only trust I'm talking about today. But to confuse you, I will tell you, there are irrevocable trusts out there. They do different things than what the revocable trusts do. I'm not talking about them. There are pour-over trusts. I'm not talking about them. We're going to talk about a revocable living trust. So to do that, let me tell you what a revocable living trust is. It's a trust that you create now. That's the living in the title. The trust exists now. Revocable means you can change your mind at any time. You can reword it, put different people in it, move assets in and out of it. You retain full control. But the downside to that is it won't protect assets. It's not a shield. Right? An irrevocable trust is a shield. So, misconceptions about trusts. A lot of people hear trust and they're like, oh, my estate's not big enough for a trust. I'm not wealthy enough. Trusts are just for the Rockefellers. That's it. That is not true. As I'm hopefully setting up for you and trying to persuade you, trusts are for people that want to accomplish certain things. So a lot of times people will say to me, my estate is only this, why do I need a trust? And I actually don't look at the value of people's estates when I advise on estate plans. I find out what their goals are. And usually when we talk about goals, they tend to lean in the trust side of things. Yes, there are different types of trusts we use. We have ultra wealthy people that need relief from all kinds of tax things that most of us collectively wouldn't even reach. But for the everyday folks, my family, the Revocable Living Trust gets the job done. So I'd like to get this misconception out of the way, because I think a lot of people hear trust and it's like, I don't have that type of estate. For me, if you live in Massachusetts and own a house, you fit the bill. Yes, is he waving?
No,
Asking? 5 houses, you're a whole other thing.
you're gonna tell me 5 years.
Well, that depends on a different bill. But for me, if you own a house, you're a good candidate. All right, benefits. Obviously, hopefully you saw this coming. If you set up a trust, you avoid the probate court. That whole dreaded process, we spent 20 minutes. I don't know if you know, I was talking about that, the sun went away, clouds came over, heard some thunder out there, but now it's clearing. We're talking about trust, the clouds broke and the sun's back out. You avoid that process. I actually made a mistake. There's supposed to be an asterisk there. Because, and this was supposed to be underlined, just having a trust doesn't mean you avoid the probate court. Only the assets that are in the trust avoid the probate court. When I talk about the drawbacks of a trust, we'll get into that, okay? I still haven't forgotten your question. I have a slide for it, that's why I gotta remember it. Privacy, right? If you couldn't tell, the idea that anyone can go to the probate court and see oh, by the way, your actual will is on record at the probate court too. I only talk about the forms, the will is there, so anyone can go read your will. Once you pass away, right? When you're not, it's in your house, everything's fine. The trust is a private document. No one sees it. You don't file it anywhere, you don't give it to any court, so it's private. You don't have WeBuyUglyHouses.com calling incessantly. And in a revocable living trust, because it's revocable, you retain flexibility. You control it. You can make any changes you want at any point in time with no consequences, just like a will. Sounds pretty good, right? We hit those things that when clients say, yeah, I want to get my assets to my loved ones as fast as possible. So I want to avoid that process. I like the idea of not broadcasting to the world what's in my estate and who's getting it. And I really like the idea that I can change my mind over things. It hits those marks. And that's when I say trusts are not about what your net worth is. Trusts are about what your goals are. Right? You heard something about 5 years over there? If a goal of yours is to protect assets, this trust's not doing it for you. Right? This trust is set up to avoid the probate court. An irrevocable trust does that. And that's a whole other set of pros and cons, which is a topic for another day. But it's not all rainbows and sunshine. Trusts have drawbacks. I would hazard to bet with you, it costs twice as much money out of your own pocket to set up a trust than it does a will. So money you're going to take out of your bank account today and pay someone to set it up is going to be twice as much as a will. But if you remember that probate process, in the long run, it's cheaper. I keep telling myself, one of these days, my presentation gets so advanced, I'm gonna have a little whiteboard. I'm gonna be able to switch the screen and draw on it for you guys and show you all this in real time. But if you add on the cost of the probate expense to what you paid for the will in the long run, you're gonna pay 3 to 4 times as much money than you would have for a trust plan. It's just that idea that I'm taking more money out of my pocket now. I like for people to kind of play the long game on that. And some people don't care. Some people actually hear all this and say, I'm dead, what do I care? And that's awesome. We'll give you a will and move on. But I want my clients' families to have the same ease of process that I have, because I see the value in that. Why? Right? Why? Why is it so inexpensive when you die? Obviously, you avoid the probate court. But you still have to do things, right? You still have to maneuver the trust, because now you are passed away, we have to get people in. Because there's no court involved, that process almost takes care of itself. So you might have some hourly fees with an attorney to set some stuff up, maybe make some deed work, whatever it is, it pales in comparison to going through that process. So that's the magic of why when you pass away, the trust's outlay for cash is a lot less than a will. But this is the one people get really hung up on. This is the one that's sticky, and I told you we're gonna spend some time on this one a second ago. A trust requires maintenance. I actually should have said a trust requires setup and maintenance. So, assets in the trust avoid the probate court, right? Set up and maintenance. I can't tell you how many times we have clients that are grieving because they lost mom or dad or both. And when they come see us to try and get the affairs in order, they are so happy because they found a trust. Oh, this is awesome, mom and dad had a trust, what do we do? And we start doing what we do, and we realize, yeah, they have a trust. Yeah, the house they owned when they made the trust, that was in the trust. Then they sold it, and they bought a new trust. I'm sorry, a new house. When they bought a new house, they never put it in the trust. So now, that's not in the trust. And now we're going to the probate court. It happens all the time. So it's one thing to create the document. The document is useless unless you take the next step, which is the maintenance. So you actually have to put your stuff into the trust. So most attorneys will help you with that. They will deed your primary residence into the trust for you when you sign your documents. That's the hardest one to do. Most people don't know how to go to the registry of deeds and do all that stuff, so we do that.
Change the owner on the deed.
Yeah, exactly. That's how you fund your house. You make the owner the trust. And then you have to go do other things. So I just did this today. Gavin, you'll be very happy. I'm doing the job. I was at one of our banks that we happen to have a personal account at that I have a business account. And I said, oh, while I'm here, and I emailed them a copy of the trust, and they changed our personal bank account into the name of our trust. So if something happens to Carrie and me, the trust now owns it, and that bank account would not go through the probate court. So there's setup work. It stinks. It's hard sometimes, because you'll get some financial folks that don't know what you're talking about, and it gets frustrating. I actually have a lot of people change banks during this process, because they realize, like, Bank of America really is hard to deal with, and they don't want to do this work for customers. But I digress. The point is, after you create a trust, it only works if you put your stuff into it. Because anything that's not into it is in your own name. If it's in your own name, it's going through the probate court. Okay? So the setup is there, and some people say, oh, that takes so much time. Yeah, it does. Yeah, it's tough. Yeah, you gotta have a list of assets. Yeah, you gotta go to places and do things that you don't wanna do. But in the long run for your family, you've made it so much easier, so much better for them. But setup's not enough. Maintenance. Attorneys attack this two different ways. Some attorneys will have you pay a subscription fee. So you'll pay for your documents, and then you'll pay a subscription fee. And what the subscription fee gives you is a guaranteed meeting every year, access to things like this that the attorneys put on. Other attorneys will just check in with you for free and see how life is, using a series of design questions that would elicit, oh, Sounds like something's different, we should come in, sounds like we have a change. And other attorneys, yet, will just say, here are your documents. Nice knowing you, this was a great transaction. If you ever need anything, we'll see you later. Those are the attorneys that I think do a disservice to people. Because those are the ones that have clients that put their plan in their sock drawer. And as life changes for those people, when we pull the documents out to use them, their life doesn't look like what their documents say. For example, I told you my mother passed away in 2014. We did our plan in 2002. At the time, we had no other real choices for guardians. So my mom and dad were listed on the will as guardians. My mother's passed away, my dad lives in Florida. If something had happened, that would not have worked for us, right? So if I had practiced what I preached, we would have updated that the same year my mom passed away, right? That's an idea of maintenance. We have to do things. The story I told you, that happens more often than not. You know, that house you first had when you made the trust is in it, then someone sells it, and the new house doesn't get in it. You might have a piece of paper in your book, or I'm going to have it up front, about a case I got asked to talk about. And this fits kind of the same category. It was this woman. You don't mind if I digress on this one, do you? This is a little off field, but it'll make sense. It cracks me up. Because you have to think about the real world logistics here. Because you have to have an estate that was worth an ungodly amount of money when you think about what I'm about to tell you happened. Because no one's going to fight for as long as this family fought and go through the court system the way this family did if the money was not, like, obscene. So this woman, she was a widow. She obviously hated her children because the estate plan she put together cut all of her children out and instead left it all to her dog, Licorice, in something we call a pet trust. Okay? The problem was Licorice died 3 years before she did. So when she died, Licorice was no longer alive. Well, the pet trust said, take care of Licorice, and when Licorice eventually passes away, all the money will go to these animal-related charities I've picked out. Well, the kids, when they saw the documents, obviously went nuts, hired an attorney, they crafted an argument. Their argument was, you know what? Because Licorice predeceased, the trust never happened. It's as if it wasn't in the will. And unfortunately, when you have these estate planning documents, if something in it doesn't work anymore, we take it out of the document, so it's as if you don't have it. And if you take that out of her documents as if she didn't have it, we have a no will, no trust. They're going through the probate court with nothing, and all the kids inherit under the, we call it intestacy laws, right? So the kids, like, we inherit. They went through the probate court, they went through the trial court, they went to the appellate court, they went to the Massachusetts Supreme Judicial Court. And what this article, the guy asked me all these questions about it, and there's other attorneys in Boston questions, and we all kind of said the same thing. We think all the money's going to charities, these kids are out, you can tell by the intent, all this awesome legal stuff. The SJC said, you know what? Kids get the money. But at the end of the thing, the reporter that I was talking to, I made a point. I said, you know what's interesting? We're all talking about the legal doctrine here. I think there's a practice tip here. If you're following up with your clients, if you have a system, whether it's a paid subscription service or you're just regularly in the habit of following up with your clients, this never would have happened. Because in that 3-year period, somebody from that attorney's office that drafted that thing has got to check in. How are things going? If they're a really good attorney, they're going to review the documents ahead of time to get re-familiar with the case, look at their notes, like, how's Licorice? Because you know she loves Licorice if she left everything to Licorice. And when she says, oh, God, Licorice passed away, you need to come in. Because if your goal is to not let those nasty kids get any money and Licorice is gone, you have a problem. Right? So that's what this funding thing is about. And, you know, as difficult as it can be, you know, it's not a lot of time. Up front, yeah, get it set up. Once it's set up, it's like a check-in, right? And by the way, I'm gonna make one second. I think you gotta do the same thing with a will, right? Not to the same degree, but if your life changes, you gotta change your will too. It's just the consequences from going from a well-funded trust to not are more dire for what your goals are than a will not. All right, what was your question?
If there are absolutely no changes in the trust, will it last a lifetime?
Absolutely.
Really?
Yep,
Oh, that's good.
absolutely. Once you set it up, it will flow according to your instructions, all right? Now, to make sure we're clear on that, while you're alive, your trust is your trust. When you pass away, you can set it up to do whatever you want. Some people will set it up to say, I want it to end and distribute money. Other people say, you know what? I told Gavin White not to marry that girl. I never liked her. And the thought of Gavin's spouse ever getting my inheritance if they get divorced is just too much for me to bear. So Gavin's share of our inheritance is going to stay in a trust. Because that way, if they ever get divorced, what's in the trust is not part of the divorce. If I gave it to Gavin, it's part of the divorce. In that situation, the money's in trust forever. Now, I might put a rule in that says when Gavin dies, do this with it. But maybe I'm even crazier. Maybe I say, not only did I not want him to marry that girl, it may be, you know what? I don't want anyone that's not blood to ever get that money. So then it never comes out and just keeps going down this bloodline until either the money runs out, because we're not the Rockefellers in our house, or not. Does that make sense to you?
Yeah, so if, in that case, you specified it's going to a certain person, it will only go to that person, not their spouses or their children.
It never goes, so that's an awesome point. Unless you say something in your plan, whether it's a will plan or a trust plan, for non-blood people, they never get it. You have to say, I want this person who's not my blood relative to get it. Because the probate laws do not account for spouses or people that are not your blood relations. All right?
If you have a trust with and you put the house in it.
Yep.
And the name changes on the deed, and you want to fund that with some cash. And then there's perhaps income from those investments or accounts or whatever. Who pays the taxes on that?
You do.
Okay.
So, I'll talk about it now. One of the huge benefits that I haven't talked about yet with a revocable living trust is, aside from funding, your day-to-day life does not change. This trust uses your social security number.
Okay.
Okay, who still writes checks? I still write checks once in a while, right? One time. You gotta order new checks. Because the checks can't say Jonathan and Carrie White, they have to say Jonathan Carrie White, trustees of the Our Great Life Living Trust, right? Sometimes when you sign things, you have to write the word trustee after your name. But day to day, it's your stuff, it's your social security number, nothing changes. So if you were getting income from those properties as an individual, how you pay taxes on that doesn't change when you put it into this trust, right? That's, again, only for irrevocable living trusts. Other trusts, different answer, okay? All right. So, how do we know when to pick what? Like, that's what we're here for, right? I told you all about it, but we gotta talk about how do we know when to pick what? Well, hopefully, again, I've led you down this road and it's pretty easy. For most people, they have a straightforward situation. We had clients in our office this week. 56-year-old daughter's the only child. She has no children. There's no real family outside of this nuclear family. It's one of those things where just the three of them, mom and dad are still alive. Yeah, we could have done all this trust stuff, but at the end of the day, all their money is going to a church that they want to support. So the question became, do you care if the church has to wait a year to get their money? No. Great. Will's good for you because it's all straightforward. Their hardest part, and they didn't want to talk about this, was putting backups in. Because mom and dad couldn't contemplate a situation where their daughter predeceased them. And I was like, listen, we have to put some people here because if that happens and she's not here, who do you want to take care of you? If we don't have a backup, you don't have the document, you don't have the document, we're running to court. So, but simple situations, right? Straightforward, if it makes sense, you don't mind the trappings of the probate world, will's perfect for you. Despite understanding that there could be out-of-pocket expense later on, if money for you, if cash flow is tight right now, fine. Will's a great thing because will is better than nothing. You don't want to be on the Commonwealth's plan. If you have no concerns about managing assets, and what I mean by that is this. A hidden value of a trust has to do with managing your assets if you're incapacitated. So you may remember when I very first started, I mentioned there were 3 documents that we weren't really going to talk about, but they're part of all this. One of which was the power of attorney. That's a form if you can't make your own decisions, someone would take that to the bank, present it. The bank's going to say, great, we're going to give it to our legal department. 7, 10, 14 days later, they'll come back and say, looks good, what can we do for you? And you're now acting for that person's behalf because they can't. Right? Awesome document, it works, it saves you. I hope you picked up on the 7, 10, 14 day delay. Because if you need immediate access, you're not going to get it. Because every bank, every financial institution, anywhere you want to bring that thing, they want their legal department to look at it. Here's a fact about powers of attorney that we don't talk about a lot. There's no legal requirement that any private company has to accept it. So it's not like I have a power of attorney here. They can say, we don't deal in powers of attorney, I'm sorry. More importantly, they can put abstract rules around what powers of attorney they'll accept. So a lot of times I'll challenge clients. I'll say, now take this power of attorney now and go to your bank. Ask them 2 questions. First question, will you accept this? And let them go through the process. If I get a no, I have much bigger problems in my practice. If someone won't accept my power of attorney, I have big problems. That hasn't happened. They work. They're good. The second question is the one that gets people. Ask the bank, for how long will you accept this document? And what comes to light is every financial institution puts their own rules around how, it's like a born on date, it's like a freshness date, like a don't use after date. Everyone puts their own thing on this. And it's crazy. I gotta retest this one. I'm picking on Bank of America. I'm sorry if I'm picking on Bank of America. We had clients come back to us that Bank of America said they won't accept it after 90 days. I was just like, are you kidding me? So if I do a power of attorney and more than 90 days pass, I need to use it, Bank of America says, sorry, go get another one. Well, I can't. I can't sign my name. It just mind-boggling to me. But that brings something to light. So, like I said, powers of attorney are a good thing. They get you help when you need it. For the most part, they'll work. You gotta wait 7 to 10 days. Some people say, sorry, it's stale. Some people are even crazier. But with a revocable trust, when you become incapacitated, any assets that are in the trust are the trust's. The power of attorney has no effect over assets in the trust. They only affect your individual assets. So guess what? If you're incapacitated, your successor trustee just steps forward and says, I'm here, what are we doing? There's no 7, 10, 14 day window. There's no, this is expired thing. So there is a asset management issue. So if we don't have any immediate concerns about that, we stick with the will plan, right? It's awesome. Because the will itself doesn't provide that. We got the power of attorney. But when we go to a trust, it brings that feature in. So these are really good indicators that, yeah, the will's going to work for me. When do we want to choose a trust? Well, we've talked at length about wanting to avoid the probate court. I won't harp on that any longer. I think we all absorbed that point. What we didn't talk about, because I don't like to talk about until we get to this point, is a revocable living trust, if set up this way, can reduce estate taxes. Now, I'm introducing a new concept. What are we talking about? The federal government has an estate tax. Right now, I don't know how many people have hit it. It's like 13 million per person, so if you're married, you get 26 million. Anyone here has that? Great, I would love for you to be quiet. And we're accepting benefactors for the White Family College Foundation right now. All right. So most people don't worry about the federal estate tax that I deal in, but we're lucky enough to live in one of 17 states that still imposes a state estate tax. And you can get lost in the different types of taxes that are out there in this world. I'm only going to talk about the estate tax. What is the estate tax? It's the fee the Commonwealth charges you to die. If your estate, now the good news is, for the first time in 37-ish years, the legislature changed the rules. They increased the amount of money it takes to reach the tax, and they changed how it's taxed, how they apply the tax. So it used to be $1 million. So I kind of go back to, if you own a house in Massachusetts, have somewhat of a retirement account, you're probably going to hit the estate tax. And they taxed you at almost like 25% at $1. Crazy. Well, now they doubled the thresholds. Now it takes $2 million in value to get there. If you get there, they only tax you over the 2. Now a lot of you are probably going, "Whew, we're good." I do a whole other presentation just on the estate tax. That's an hour. So I'm giving you like the Cliff Notes version of this. You might be good when the first spouse passes away. Let's say you have no plan, you have a will plan. Let's say your overall estate is worth $3 million. A lot of people are like, there's no way I'm there, but when you actually think about it, when you put your house in and some other stuff, more people are there than they think are there. What happens practically is when the first spouse dies, the Commonwealth will split the estate in half. $1.5 million to the surviving spouse, $1.5 million to the deceased spouse. We don't hit the $2 million threshold, no estate tax, life goes on. Great, we did it. What people forget is, well, now we have a surviving spouse that absorbed $1.5 million from the deceased spouse, that adds it to their $1.5 million, now they're at 3. And, you know, it's probably not gonna stay at 3. Hopefully it goes up and there's investments and house values, but it's not gonna stay at 3. So when a surviving spouse passes away, we're at 2. Without planning, without the relief a revocable living trust can give you, you gave them $500,000. Because when they took your $3 million estate, they split it 1/2, 1.5, 1.5. You had enough to get to 2, so you gave the Commonwealth $500,000. These trusts have mechanisms built in so that if you hit the estate tax, they will turn on. And when the first spouse passes away, it grabs enough money to hold in abeyance and takes a wait and see approach. So when the second spouse passes away, the mechanisms do their thing and it either reduces the tax or eliminates it entirely. It's like magic. So, if you are worried about the estate tax, and by the way, your estate pays it. So basically, if you have this money, if it gets there, your trustee or your personal representative pays the tax, then we move the money. So no one receiving money in Massachusetts as an inheritance pays a tax. But these trusts can eliminate it. And then lastly, with the revocable living trust, you can still control your assets, right? We talked about control your assets. So those are the factors that most people think about when they want to choose a trust, right? We've already met probate, court, and all the trappings, reduce the taxes, maintain control. So you got all this information. You kind of understand the difference. How do you get yourself set up now? Remember the goals I had? Hopefully I made it simple. And hopefully I empowered you to act. So how do you get your ducks in a row? Well, you're kind of doing the first thing. You're consulting someone that on the outset knows what they're doing. All right? Explain to you how it works. But you gotta kind of go home and make some decisions. You have to inventory your assets. And not like in your head. Not like, oh, I think I got this, I think I got that. Like literally write on paper what you have. Real estate, investment accounts, bank accounts, any asset. Don't worry about the amount of the mortgage. Just write down the assets. Because it's one thing to think about it here, it's another thing to see it on paper. So when you start seeing it on paper, you can then say, okay, all right, I'm starting to get an idea of what kind of a plan I think I might need. After you inventory your assets, you start thinking what's important. Is cost the biggest factor? Speed, privacy, some combination, right? You kind of think of those. You kind of see what's happening. You're teaching yourself kind of how to help guide your decision-making process. You just kind of start thinking about, how do I want to leave stuff to my people? How do I want this to happen? Who would I put in charge if I'm running? You start kind of thinking about these things. And when you get all those things kind of put together, yeah, it's then time to figure out, how am I going to accomplish this? But by taking some of the knowledge you have here with some of these steps, you get a head start. So when you go consult with someone, when you go to put this in place, you're better prepared than if you had it. This was me, right? Luckily, I had someone around me that said, no, you gotta get this done, it's too important. But, you know, a lot of people will sit there and do what I did and say, you know, I don't wanna make this decision, I'm gonna wait till tomorrow. Don't wanna make this decision, wait till tomorrow. So, you know, when I came across this quote, I put it in a lot of my estate planning presentation. It's true. It is really true. And next thing you know, it's too late to do something. So, I had to get this mindset very active and top of mind to do it for me. As we start to kind of wrap things up, one thing I want to do, I do appreciate that you spent some time with me tonight. I really do. So if you liked what you've heard and you want to work with us, we're going to give you 20% off our estate planning for sitting here and, you know, listening to me. Most people would consider this a hostage negotiation, so that's how we're going to let you out. I know it says like schedule an appointment today. Anne Marie knows if you're at the seminar. You know, if you want to schedule, she's there. If not, we know who you are. You'll get the 20% because you were here. And that's, I really am grateful that you're here, that you're giving me the opportunity to show you why this is important. Now, sometimes people don't want to raise their hands and ask questions. You've been very good, but I always have a slide prepped in case I get people that don't want to. And I take some of my most common questions, one of which came out early. Do I need a lawyer to do this? You asked that, right? What's your name?
Carol,
Carol. What do you think I'm going to say? And I'm not being a wise ass, I'm being helpful. What do you think I'm going to say?
no.
Okay, that might surprise you. Why do you think I might say no?
Well, I don't know. I don't know anyone that's done it. I'm just
Okay.
curious, thinking,
So-
why couldn't I do it myself?
Here's the answer to this question. No. You do not need to hire a lawyer to do this. Is that shocking that I'm trying to get business from you with a discount and telling you you don't need a lawyer to do this?
Good.
Yeah. The reason why is I'm confident what I tell you next will say I'm going to see an attorney to do this anyways. So no, you don't. There are self-help books. You can go to Staples and they have software and thumb drives, and you can go to the internet and go to like Rocket Lawyer, Matter, and they're telling you like $75 wills. And yeah, what I will tell you, I really honestly believe holds true. In the estate planning world, you get what you pay for. Even in the world of attorneys, you're going to find a gamut of pricing. But you kind of see there's a bunch of attorneys in the middle. There's a reason for that. Right? There are some people that need the most expensive ones because they're special. I think almost anyone should avoid the lowest paying one. We get tire kickers all the time, and we're not even saying, hey, listen, if you're looking for the cheapest price, we're just not the lawyer for you. Because you get what you pay for. And here's what I mean by that. If you go to those Rocket Lawyer websites, read the fine print. Because it'll tell you, we're not lawyers, we don't represent you, we're not giving you legal advice, you're just accessing forms that really play like Mad Libs, And you should take this stuff and bring it to an attorney in your jurisdiction to review it, to make sure it's good. And we have clients that do that. We say, great, what did you pay for this? I'll take it off my fee because you wasted your money. Let's start from scratch. So that's kind of part one. You get what you pay for. You're not going to get a really good plan if you go to Staples and pull it off the shelf. If you Google it, find a free thing that someone put on, you get that. Secondly, what if you don't know how to make decisions? What if you need guidance? What if you need someone that says, well, I can see why you want to do that. You have 3 children. You want to make them all your personal representative at the same time. That's fair. But in my practice, when I've seen families appoint more than one person to serve a role at the same time, especially when it's an even number, and one sibling or one person doesn't agree, we might as well not have a document in place. So you lose that experience to give you guidance and advice. And then lastly, if you do go in the trust world, you need guidance and help funding that trust because you can really mess that up. So I cannot tell you have to have a lawyer to do this. There are plenty of avenues to go do it without one. But I think when you try it on your own, your mileage varies. We had a probate. We're done with that probate now, right, Emery? The one the family came from out of state, the brother, that's done now, right?
Yeah.
Okay. We had someone come to our office. Do you mind? I hope you don't mind me tell you like this is what happened with us because I think it's helpful. We had a family come to us. Their son suddenly passed away. They lived in Middleton, and they were again happy as all could be. He had a will, but he did it on his own. And we looked at it, and it didn't meet the requirements whatsoever. Wills and trusts have to be executed under certain standards to work. This person got a piece of paper and just didn't do it. So again, he didn't have a will. So those are the things you see when people do it on their own.
That's what I was going to ask you, is what makes it legitimate? The trust or a will, just a piece of paper.
Yeah, there's a certain cadence at the signing process and documenting that makes it work. And it's a combination of witnesses and notaries.
Okay.
And it's not just having the right numbers, but it's having the right language on the documents. So essentially, what witnesses do to estate planning documents is they authenticate them. If you think of like old movies, and you see people like signing wills, they're like, we attest that you're over 18. Yes, I'm over 18. You're of sound mind. I think so. Like there's a whole cadence you go through, and you also document it a certain way on the documents. So the witnesses authenticate it. The notary self-proves it. So you can have a will that is witnessed but not notarized. The difference is you have to now, however many years later, find those witnesses and bring them to court. So they can attest at whatever time in the past they signed as witnesses, everything they said was true and the person did this. When you notarize it, it adds a self-proving element, and the notary removes the requirement to dig those folks out of whatever hole they're in and bring them into the court. So that's a combination of the two, and it's not just having them and having the right numbers, but it's having the right language in the attestation, see, fancy words, clause. So, I hope that answers your question. I think I've talked about this enough today, but people ask, how often should I do it? I think as a person who's holding a plan, you want to pull it out every year. You want to look at it, see what's in it. Sometimes you might think you remember what you did, but you remembered wrong. Someone like me, so I don't offer a subscription plan. I haven't gotten there yet. I don't like that model. We check in, and our cadence can be every year, it can be every other year, depending on what we're hearing from people. But you can check in yourself. Are there any other questions?
Need one, not both, you don't need a will and a trust.
I forgot about that. Thank you for reminding me. Can't believe I forgot that. So, when you have a will-based plan, the will's the document, there is no trust. I hope that's obvious. When you go to a trust-based plan, in any kind of a trust-based plan, in our case, a revocable living trust, we still give you a will. There's a couple of reasons why. The first goes back to one of those points when I meant you can only do in a will. If you're a person that's doing a trust plan that has minor children, we have to give you a will so you can appoint a guardian. If you don't have minor children, the will serves a different purpose. It acts like a safety net. So that if you have assets that are not titled in your trust, the will catch it, run it through the probate court, but get it into the trust. So we don't avoid that process, but we get it there. Because there are reasons why we want everything to ultimately get through the trust anyways. So it's a safety net. So yes, with a trust plan, you get the trust, a will, healthcare proxy, power of attorney, HIPAA form, all there. Is that, okay.
When you have a trust to protect your assets, it's not effective until 5 years, is that correct?
Sort of. Before I go down that rabbit hole, there was one other point I was going to make. It'll come to me as I'm talking about that. So remember, the trust I'm talking about tonight, a revocable living trust, does not do what we're about to talk about. The revocable living trust avoids the probate court and can give you estate tax relief. Because you retain control over your assets, you get no creditor protection. You cannot shield because you can just put your hand in and take it out. When you want to shield assets from creditors, we use irrevocable trusts. A difference between that is once you create the irrevocable trust and fund it, it's not yours. Forget about control, it's not yours. You cannot be the trustee and you cannot be the beneficiary. It's harsh. We use this thing called a trust protector, just picture me with a red cape, where we can pull some levers, meaning I can change who my trustee is or my beneficiary. So if, for example, I'm trying to protect my primary residence from Medicaid, I'm getting to 5 years. But I wanted to downsize, and I said, hey, Gavin, you're my trustee, sell it. And he's a wise guy and says, I know the rules of that trust, and I'm greedy, and I want that house. I don't have to listen to you. With the trust protector, I can then basically access that trust protector and say, trust protector, get Gavin out of there as the trustee, put Thomas in, he's the smart one, he'll sell it. And they can downsize it, and they can sell it and use the cash to buy a new one all within the trust. Right? That's what irrevocable trusts do. When you put it in the irrevocable trust, it shields assets from entity creditor from day one, except for the federal government. The short reason why is attorneys like me have found all kinds of loopholes to elude assets from the federal government. And we've gotten so good at it, they had to say, you know what, we can't keep closing all these loopholes, we're gonna put a time thing on this. So if you are interested in using what we call a Medicaid Asset Protection Trust, which is a form of an irrevocable trust to shield assets so a federal government can't take them to reimburse for Medicaid that they paid in your lifetime, a key part of that is it won't work for 5 years. Because when you apply for, or someone is applying for you, you won't have capacity to apply, you have to give the government a 5-year history of your financial transactions. And by the way, it's a federal benefit, but Mass states administer it. So you're really dealing with Mass Health. Mass Health applies a set of rules to those transactions. If you're found to have violated them, meaning you transferred your house out of your name, whether it was for money, into a trust, or to your kids, you did that just to qualify. And we're gonna penalize you. They determine an amount of time you have to pay on your own that equates to a value of the house. That's how they penalize you. So yes, if you're using a Medicaid Asset Protection Trust, for Medicaid protection, you need 5 years before it's really good. Okay?
And then, there's no way around that.
Absolutely, positively not. I wish there were.
But they can change that, right? Isn't there a chat that they're turning into?
Yes.
Like a 7
10.
look back?
10. Yes, attorneys like me have gotten so good that we're now using the trust protector to get people to use these trusts earlier than before. Because the trust protector is a newer concept in the estate planning world. We used to not have it. So it used to be if you put your house in this trust, you just have to hope your son, your daughter, whoever's the trustee would just help you. And attorneys like me would have signing meetings and bring those people and say, so you know what the scheme is here, right? Like, you're not really in charge. We need you to do something if we need you to do something. This is to protect the thing so you can get it. But if we need to do something, you're going to play ball, right? The trust protector changed that. Because now we have to have that kind of, now it's, you don't want to do it, we're just changing you out. So because of that and some other stuff, the government's like, more and more people are qualifying. So what's the next thing we can do? We can't close any more of these holes. They've all figured them out. We can just make the ramp up longer. We're getting past the time, but I just want to close this one little thing. And I want you to just understand the reason why this happens. So no one comes and takes your house. A nursing home does not come and take your house. The government does not come and take your house. There are 3 ways to pay for hospice long-term care. You either have a long-term care insurance policy, which not a lot of people have. You pay for it yourself. That's the first way people lose their house. The nursing home doesn't take it, but you have to sell it to take the liquidity out of it to pay for your care. Or you qualify for Medicaid, and that's a need-based benefit. You can't have more than $2,000 in assets if you're sick. If you have a healthy spouse, I think the number's $154,000. Point is, you have to qualify. The government wants to give that benefit to people that need it. So a lot of people said, we can find ways around this and make it appear as if we don't have these assets to protect them to give to Gavin. Your house, your primary resident, is not an asset that they count when they're getting to the $2,000. You want that to sit in. When you're doing this, the value of your primary residence does not affect the $2,000. That is not because the federal government is nice and want people to live in their houses. It's not because they hope they get better and get to move home. It's because it's not really a benefit. To me, a benefit says we're giving this to you with no expectation of repayment. Medicaid's not a benefit. There's 100% repayment. When you pass away and you're going through that probate process, one of the things, I didn't talk about because I didn't have to, which was one of the other benefits of probate, is when we file things with the court, someone like Anne Marie has to send all kinds of stuff to Mass Health. And they look through their records. And guess what? If you receive Medicaid benefits, we get an awesome letter about 3 weeks later that says, congratulations, this estate has a lien on it. And because the house is in your name, and they didn't make you sell it, they didn't count it, the estate now has an asset. And your family has a choice. Sell the house and pay the lien, or do they have enough cash to pay the lien and keep the house? That's how people lose their houses in long-term care. They have to sell it, or it goes in a lien situation. So that's just closing that loophole. So you got me to talk about irrevocable trust, and I said I wasn't going to do it tonight. Thank you very much. I appreciate your time and attention. I went a little longer than I should have, and I appreciate you bearing with me. Because I went longer than I should have, we, in addition to 20% off, if you want to work with us, we actually have another surprise for you. I like to say I partnered with the Texas Roadhouse. Read that to say my middle son works at the Texas Roadhouse and came to me and said, Dad, I know you like to put your logo on anything. And Dad, I know you always want to support what we do. If you buy so many gift cards, I'm in a thing to win a thing. So on your way up, please see Anne Marie. We have some gift cards to the Texas Roadhouse. They're good at any Texas Roadhouse, but there's the one in Danvers. And enjoy the Texas Roadhouse on us. And who knows? No, Caleb's not working anymore, right? 'Cause he's going to school. So
Still get the gift card.
yeah, thank you. Please hand me the gift card, and I appreciate your time and attention. Thank you.